This is David Rubin. I'm here with my colleagues, Chris Lindstrom and Natalie Capolazzo from Nutter. We're here to talk about the new final rule, the FTC's final rule banning nearly all non-compete agreements. Thank you so much for joining us. We're really glad that you came and that you're here. I'm going to give just another minute or so because I could see the numbers still moving, but we'll wait another 60 seconds and then we'll begin. All right, Natalie, you want to move us through, I guess? Thanks. Well, that's us. So our agenda for today is we're going to talk briefly about the background of the final rule. That is, how we got to this point where we are today. And then Natalie is going to walk us through sort of the content of the rule itself. The content of the FTC's final rule and focusing specifically on the various exceptions and applicability standards that are set out in the rule. And then Chris will be talking about the timing of the rule, as well as the ongoing litigation regarding implementation of the rule. I'm sure you've all heard of that. And lastly, we'll stop and talk about some next steps and some of the more basic questions that we and everyone else are asking. So if we move on then to the next slide. So let's talk about the background of the final rule. So, for the last however many decades that non-compete agreements have been ongoing, and it's been many, here in the US, it's always really been a matter of state law, right? Different states regulate non-compete agreements in those states, the enforceability of agreements in the courts of those states. And that's always been the way it's been. And, as we all know, there's been a lot of movement in the various states, both in their legislatures and in their courts. Some states have really moved dramatically towards precluding them. California, as you know, has long precluded virtually all non-compete agreements. Massachusetts now has, since 2018, sort of stringent limitations on what you can do and can't do in a non-compete agreements. Other states have moved in those directions. There are some states that are very strongly pro non-compete agreements. I think to some measure believing that there's a pro-business, pro-competition concept. So we see a great diversity among the different states themselves, but the point of it is that it is and has long been a matter of state law as to whether and when a non-compete agreement will be permitted or enforceable in that state. Now, when the new administration, the Biden administration, took office in January of 2021, trying to get my dates right. It would have been January of 2021 would have been when they took office. One of the first things they did was they issued an executive order a few months later in July 9th, 2021. They issued what was called an executive order on promoting competition in the American economy. And it had many different components. It addressed technology, healthcare, labor issues, a whole range of different issues in this one executive order. But one part of it said that the FTC, and to a lesser extent, the Department of Justice, were encouraged to make the workplace and the labor market more competitive and to eliminate and reduce anti-competitive measures that we find in the workplace. And one of the specific recommendations of the executive order was that the FTC, the Federal Trade Commission, was encouraged to ban or limit non-competition agreements. And for matter of reference, the Federal Trade Commission is a a longstanding federal agency established back in the early 20th century for the purposes of enforcing and promoting anti-competitive measures or measures that would preclude anti-competitive activity, excuse me, in the marketplace for everything, right? You know, monopolies, trust busting, all the rest. So in any event, that's, you know, the executive order in July of 21 encouraged the FTC to do something to ban or limit non-competition agreements. So then a year plus later, in January of 2023, January 5, 2023, the FTC issued a proposed rule. You know, when a federal agency issues a proposed rule, an administrative agency issues a proposed rule, they call it the rulemaking process. You know, it's then published for public comment. And after consideration of public comment, then the agency, you know, can go ahead and issue its final order or final rule based upon how it has synthesize those comments into its rulemaking process. And so read somewhere recently that they received 26,000 comments in response to the January 5th proposed rule. And then in, I'll jump in the middle here. While we were waiting for the proposed rule to be made final, for the FTC to do something on that proposed rule, the National Labor Relations Board, General Counsel, never to be outdone, sort of jumped in the middle and issued its own guidance, memorandum, saying that non-compete agreements would violate the National Labor Relations Act in most circumstances, not all, but most circumstances in the private sector. That NLRB decision, that NLRB memo is really unrelated to the FTC here. I raise it only because we've seen a lot of confusion regarding these two things. So that NLRB memo exists entirely separate from what the FTC is doing now. But that was issued in May of 2023. I understand there's some litigation ongoing at the NLRB regarding that memo itself. But again, that's separate and distinct from what the FTC has been doing. So then just whatever it was, a week and a half ago, on April 23rd of 2024, the FTC issued its final rule based upon the proposed rule and the comments that it received over the previous year. And that's what we have now before us, a final rule issued by the FTC on the issue of non-competes. So with that, I'm going to turn it over to Natalie, who is going to walk us through what the rule says and what it doesn't say, and take it away, Natalie.
Thanks, David. Hi, everyone. So as David mentioned, I'm just going to sort of go through some of the specifics of the substance of the rule. High level overview, what the rule says is that it is an unfair method of competition for an employer to enter into or attempt to enter into a non-compete, enforce or attempt to enforce a non-compete, or represent that a worker is subject to a non-compete. Critically, the term worker is very broadly defined under the rule. So a worker includes any natural person who works or previously worked, paid or unpaid, without regard to the worker's title or status under any other state or federal law. And it includes employees, independent contractors, interns, externs, volunteers, apprentices, or any sole proprietor who provides a service. So a pretty broad definition. It also includes any natural person who works for a franchisee or franchisor, but in the context of a franchise relationship, the actual franchisee would not be considered a worker. So further, the rule defines a non-compete clause as any term or condition of employment that prohibits a worker from, penalizes a worker for, or functions to prevent a worker from seeking or accepting work in the US with a different person after the conclusion of the employment that includes the non-compete, operating a business in the US after the conclusion of the employment that includes the term of or condition, so the non-compete. And then I just wanted to, so that's sort of an overview of what exactly the rule is preventing. Most existing non-competes that we think of, like the traditional non-competes that say you can't go work for a competitor or you can't start a competing business, would obviously be swallowed by the rule and prohibited. Just wanted to touch on the notice requirement. So the final rule requires, when it does, if and when it does go into effect, requires that employers notify workers with unenforceable non-competes that those non-competes are no longer in effect and that the employer won't be enforcing them. And I just pulled sort of a screenshot of the model language that the FTC has published. So you can see here that, again, if and when the rule goes into effect and employers have sort of taken a look at their non-competes and other restrictive covenants to see what is and isn't enforceable, they would then generate, employers would then generate notices that look like this to tell the employees, you can accept any job, even if it competes, you can run your own business, even if it competes, you know, for the avoidance of doubt, you may compete. So pretty straightforward, but this is available on the FTC's website in Word form. So employers, again, if the need arises, will be able to sort of just tailor this for their existing non-competes. So getting into some of the exceptions to the rule, existing non-competes with senior executives are carved out. So if you have an existing non-compete with a worker who meets the definition of a senior executive under the rule, that can stand. You cannot enter into, after the effective date, a new non-compete with a senior executive, even if they meet this definition. So who does the rule view as a senior executive? This would be a worker who has a policy-making position. So the president, the CEO, or the president CEO equivalent, some, you know, really high-level position, or any other officer of a business entity that has policy-making authority. And policy-making authority means final authority to make policy decisions that control significant aspects of the business. And the rule makes clear that just having policy-making authority over a subsidiary or an affiliate is not sufficient, and the executive isn't considered to be in a policy-making position if they don't actually have that authority over the whole enterprise. So just having that authority over an arm of the business is not enough. And then the executive must have earned $151,164 in total annual compensation in the preceding year. And interestingly, this is one of sort of the few areas, I guess, of flexibility, we can call it, where an employer can look back at either the most recent 52-week year, the most recent calendar year, the most recent fiscal year, or the most recent anniversary of hire year. So that look back period can sort of change depending on, I guess, you know, if you're looking at it from the employer standpoint, if that look back satisfies that threshold of compensation earned in one way or another, you can elect to look at that that year, preceding year. Another exception, non-competes entered into pursuant to the bona fide sale of a business. This isn't really anything new. We've seen this in other states that have laws that curtail the use of non-competes. There's often a carve out for the sale of a business. And then existing causes of action are also exempt. So the final rule does not apply where a cause of action related to a non-compete accrued prior to the effective date. So this includes, for example, where an employer alleges that a worker accepted employment in breach of an existing non-compete, if that breach occurred prior to the effective date. And based on that sort of guidance from the rule, my read of this is that an existing cause of action means what the FTC is saying here, the breach occurred prior to the effective date, it doesn't necessarily mean that you would have had to initiate litigation prior to the effective date. It can't hurt, right? Like if you have sort of a non-compete case potentially brewing, and you want to preserve your rights, probably best to initiate action before the effective date. But again, the rule makes clear that this is a cause of action that accrued where there's been a breach prior to the effective date. There's also a safe harbor provision that says that it's not an unfair method of competition to enforce or attempt to enforce a non-compete or make representations about a non-compete where there's a good faith basis to believe that the final rule doesn't apply. But obviously we would advise consulting with counsel before taking a position that the rule doesn't apply to a certain non-compete, given the breadth of the law generally. Just a couple of points on applicability. The rule does not apply to most nonprofits and certain banks that are outside of the FTC's jurisdiction. One important note with regard to nonprofits, the commission stresses in the final rule that not all entities claiming tax exempt status as nonprofits would necessarily fall outside of the commission's jurisdiction. So in other words, just because an organization claims that status doesn't inherently mean they're off the hook, so to speak. The FTC uses a two-part test to determine whether a corporation is considered to be organized for profit and thus subject to the FTC's jurisdiction. And that test focuses on, one, the source of the income, so whether the corporation is organized for and actually engaged in a business for charitable purposes, and two, the destination of the income. So does the corporation or do its members derive a profit? So that's sort of what the FTC will look at to determine, who's exempt, what organizations are truly exempt because they're a nonprofit. And then the rule does not apply to banks, but it does apply to bank holding companies and other non-bank affiliates of FDIC insured banks. So if there are questions as to whether a bank or a bank adjacent entity is subject to the rule, that would be an area to consult with counsel on and look carefully at the rules regarding the FTC's jurisdiction. And then last thing I'll touch on this is that the rule applies to US based restrictions only. So a non-compete that prevents a worker from engaging in work outside of the US, arguably outside of the jurisdiction of the FTC, and therefore the rule wouldn't apply to those restrictions.
Hey, Natalie, before you move on, I just wanted to ask you, and I know you mentioned this, but on the distinction for the existing non-competes with senior executives, could you just talk a little bit about what it says, what the rule says about, senior executive restrictions going forward? That is,
yes.
Yeah, I just want to make sure we emphasize that.
Yeah, thanks, David. That's an important point. So as we noted, existing non-competes are exempted, but companies cannot enter into new non-competes after the effective date of the rule, even if they're entering into them with someone who would be considered a senior executive. So going forward, new non-competes with senior executives are also prohibited.
So just so I'm clear, so once the rule is in effect, then regardless of whether you have a CEO making more than 151K, you still couldn't enter into a new non-compete with that person.
Correct.
Okay, thanks.
And I think with that, I will be turning it over to Chris to talk about the timing of the rule. Thanks, Chris.
All right, thanks, Natalie. So as Natalie mentioned, the FTC's non-compete rule is not yet in effect. The rule actually doesn't go into effect until 120 days after it is published in the Federal Register. So not even 120 days from the announcement from a couple of weeks ago. It has not yet been published, but it's expected to be published today. And perhaps it's been published as we're speaking right now. Which, if it is published today, would make the effective date September 4, 2024. And so that's kind of that's the date we're all looking to, again, assuming it is published today. But you're looking at sometime in early September. Of course, we, like so much in life and especially in politics these days, the rule is also subject to multiple lawsuits from various industry groups already, including the U.S. Chamber of Commerce. And so these cases, which, everyone, they had their complaints all lined up, ready to go, because everyone kind of assumed that the final rule would look similar to the initially announced draft rule. And so they filed, within a day of the announcement of the final rule. And what the cases are looking for are nationwide injunctions to stop the rule from becoming effective. And they've been filed in favorable jurisdictions, as you can imagine. And it's similar to the playbook that plaintiffs used when they enjoined the Biden administration's vaccine mandates, if you recall that from a couple of years ago now. And so if you recall there, we had injunctions that came and went until finally the Supreme Court stepped in to make a ruling on the issue of whether the Biden administration overstepped administrative authority. It's too early to tell here whether it's going to go all the way to the Supreme Court, but it is more likely than not that the plaintiffs are going to receive similarly favorable results in the courts early on, including what I would guess is at least one temporary injunction before the rule comes into effect. So in the end, most practitioners in this space are skeptical that this is going to go into effect in September without a hitch. And it could end up being that the rule is either delayed or maybe the rule never sees the light of day, and it once again becomes up to Congress to pass something if we do want federal non-compete legislation. So there's, as I mentioned earlier, there's a case in Eastern District of Texas, there's a case in Northern District of Texas, and there are others as well across the country, but those are likely the ones that are going to be decided first. And the way the courts have already scheduled hearings such that a decision on an injunction will take place before the rule goes into effect in September. It's fairly obvious why plaintiffs chose Texas. And it, because they're probably going to get a favorable district court judge, but also because the appellate court there is widely recognized as the most favorable to these types of arguments against what is arguably administrative overreach. And so then, the questions are, what exactly are the arguments? Why can't the FTC do what it is doing with respect to non-competes? The FTC issued a lengthy memorandum in support of the reasons why non-competes stifle competition. And so the FTC is saying, well, we have the right to eliminate unfair competition, and we think non-competes are unfair competition. So we're going to issue this rule. But the plaintiffs in these cases, their primary argument is under what's called the major questions doctrine. And, industry groups have challenged the final rule on the basis that Congress did not offer the FTC what's called a clear statement of authority on the issue. The major questions doctrine, applies a heightened scrutiny if the administrative rule involves a matter of great political significance or is deciding a debate across the country. And also if the agency seeks to regulate a substantial portion of the U.S. economy. And finally, if the agency is looking to take on issues that are traditionally the province of state law. And so if you think of those three factors, as David was talking about the issues earlier, plaintiffs probably have a pretty good argument here. It's an extremely political issue. It's going to, this has typically been reserved to the states to decide over the years in terms of if you're California, you want non-competes. If you're Florida, you don't want non-competes. And if you're Florida, you permit many non-competes. And by the FTC's own estimation, they said that this rule is going to impact 1 in 5 U.S. workers and could have a favorable economic impact of over 400 billion. So it sounds like there might be a substantial impact on the U.S. economy. So that's the primary argument, but there are other arguments as well, in that the plaintiffs are arguing that the FTC has overstepped its rulemaking authority. The final rule states that the commission is proposing this rule under Section 5 and Section 6G of the FTC Act. And essentially, Section 6 allows the FTC to make rules and regulations for the purpose of carrying out the provisions of the Federal Trade Commission Act, which includes to eliminate unfair or at least minimize unfair competition. And historically, that provision's always been read to mean the FTC can issue procedural rules, not substantive rules. But now the FTC is looking to extend that rulemaking authority to very substantive law in terms of regulating non-competes. And so there are related arguments as well that Congress should not be able to delegate such an issue of significance to the FTC in this broad fashion. Typically, Congress is supposed to, if they're transferring powers to pass what are essentially laws, but seen as regulations, Congress is typically supposed to make it a, have an intelligible principle, is what they say, in terms of how the act is supposed to be implemented by the administrative agency. So the argument here is that, a vague reference to unfair methods of competition in the FTC Act isn't really an intelligible principle sufficient to allow the FTC to ban non-competes across the country. There are additional arguments which, really interest lawyers, but don't have a practical effect on what we're talking about here today. But the bottom line is that this rule is going to be subject to extensive litigation, and in all likelihood is not going to be put into effect in early September, but perhaps it could be. And so, we don't know for sure at this point. And since some of the rules provisions require employers to do things before the rule is actually even gone into effect, that's why most of us in the employment bar are recommending kind of a wait and see approach, but also with a little behind the scenes preparation just in case. And so, we'll get into a little bit more in terms of that in the next topic with respect to, next steps and questions that we may be having to deal with over the next 4 months at least. So I'll turn it back over to David to walk us through that.
Thank you, Chris. And so even as we're talking through this, I mean, I've got more questions than these coming up as I'm just thinking about it, listening to what both you and Natalie have been saying. But I mean, this is a little bit of a game of chicken that we're in, right? Because if everything just stays the same, then comes whatever that date is in September, everyone's got to be in compliance with this. And do we have any sense, and I'm, Chris, I ask you, do we have any sense when we might likely hear a decision? Or do you think it'll be close to the actual implementation date?
It sounds as if one of the courts is going to likely have a hearing, but I don't know if that means they're going to have a decision right then, or it might be soon after. But the way these courts that they're in usually operate, especially in Eastern District Texas and Northern District Texas, they should move swiftly. And therefore, I would be surprised if we don't have at least an update or an inkling where things are going to go within, probably by the end of June.
Oh, interesting. Okay, well, so I mean, so the first question, in terms of what do we do next and what do we keep doing or not do, that, we've been thinking of is that, what about existing state laws? And, I think this is relatively an easy one. That is unless and until this FTC rule comes into place, we have to continue to comply with the state law. And we need to focus on what the applicable state law, depending on where the employee is, where the employer is, all of that kind of arithmetic that we usually do in these contexts. We need to ensure that we're still in full compliance with the state law that we're dealing with and continue to operate under the auspices of that state law. One point I'll add about the FTC final rule is it says that it preempts or precludes all state laws that are contrary, right, or contradictory to the FTC rule. So, any state law that permits non-competes, like Florida, or that, regulates, non-competes in a more controlled way like Massachusetts, those would be precluded, right? Those would be preempted by the federal law, by the FTC rule, because they are contradictory. Whereas I believe that the California law would probably be, stay in effect. I'm not sure it matters, since they both prohibit, I guess whichever provides the broadest prohibition on non-competes would be the one that would be enforced. But, as I said, unless and until the FTC says something different, unless and until the FTC rule becomes final and is implemented, we need to ensure that we're fully compliant and in conformance with the applicable state law that we're dealing with under whatever agreements or workplaces we're talking about. One question that's, sorry, go ahead.
I was going to add, David, that it could be that, for those states in which don't have any statutes on non-competes, the courts always look to the, the common law and in terms of reasonableness for whether a non-compete should be enforceable. So I would imagine that there's going to be a usage of the FTC rule by folks trying to get out of non-competes, in the interim in those states to say that, listen, everyone agrees non-competes, on the whole are unreasonable and therefore this one shouldn't be enforced here. So I could see it being used as another, arrow in folks' quiver when they're trying to get out of non-competes. But you're absolutely right that if it, a state law, you still got to follow Massachusetts law. We've been trying to do that for the last 6 years now. And, but in California, even for senior executives with policymaking authority, that you still can't have a non-compete. So.
Right. Well, I think your point about citing the FTC rule, we've seen that already in Massachusetts with regard to the Massachusetts law. The Massachusetts law went into effect in 2018. And it didn't apply to agreements that were signed before 2018. But we've seen in a number of, lawsuits, plaintiffs fighting, challenging non-competes, older non-competes, saying, well, this new law shows what the policy, and the public policy of the Commonwealth is or should be, and it should still be applied even to the older agreements. We're very likely, I think, probably to see something similar, with regard to the FTC. So with respect to the question of another question we've received is from a number of senior executives and professionals that we have worked with in the past. They've said, "Oh, can we just ignore our current non-compete, or this means I don't have to abide by my non-compete anymore?" Chris, what do you tell those people when they call?
No, at least not yet, because you see all the news articles and everything, and it makes it sound as if non-competes have already been banned. Of course, the same thing happened with the NLRB announcement, that David mentioned earlier. I recall receiving all the phone calls then from people saying, "Oh, non-competes don't exist anymore. Therefore, they're all invalidated." And so, especially for those senior executives, you're not going to be able to ignore the existing non-compete, even if the rule does come into effect. But for the, for lower level employees, for lack of a better phrase, some folks may want to think about if you were considering making a move to a potentially competitive employer, if you think the rule is going to come into pass, you may want to wait a little bit before you do that. Because as Natalie mentioned earlier, if you breach your non-compete before the rule comes into effect, a former employer can still sue you, even after the rule does come into effect.
Well, that raises another question that we don't have down here, and I don't mean to ambush you here, Natalie, but I was thinking about it as you were talking, and that is, so if a pre-rule or pre-final rule agreement for a senior executive will be enforceable, for those employers that, don't currently have non-competes in place for their CEO and for their senior executives, should they be thinking about getting them into place now quickly?
Yeah, I mean, I think that again, it's still unclear whether this is going to actually take effect, but if it does, you would want to have agreements in place with those top key people, especially, knowing that they're going to be carved out. So I don't think it hurts certainly to take a look at the workforce and say, who really should we have these in place for? I don't think I think, employers obviously need to be careful about making sure the definition of a senior executive is met, and it's a pretty high bar. But if those qualifications are met for certain employees, executives, I think now would be the time to get those agreements in place.
And
Yeah,
also, if you think your agreements might be too broad, if you've been, some folks have been using the same agreements for the last 20 years and they may have a 3-year non-compete term or something that courts are likely not going to enforce. And so, now's your window to make those changes, because once the rule comes into effect, you can't make the changes. You're stuck with, even for the senior executives, you're stuck with whatever you have, right?
right.
Yeah, so probably a good time to just visit non-competes and restrictive covenant agreements across the board.
Well, then that raises a good question about, well, what about other restrictive covenants, right? So when we talk about restrictive covenants, we talk about non-competes that say you can't go to work for a competitor, but we also talk about non-solicit agreements. You can't solicit our customers, you can't solicit our employees. We talk about non-disclosure agreements, confidentiality agreements, all those kinds of other restrictive covenants. What effect, if any, does the FTC final rule, or would the FTC final rule have on those other kinds of agreements?
Yeah, sure. So I think that because the rule and the rule makes clear that the language is any restrictive covenant that has the effect or functions to prevent an employee from working after employment would be considered an unfair restraint and would be prohibited. So in the case of an NDA, an overly broad NDA that prohibits super broad swaths of use of information, could be considered the same thing as a non-compete under the law. So for example, if you have an NDA that says an employee can't use any usable information or any information that was gleaned during employment, even, and doesn't have an exception for publicly available information, basically prohibitions on such broad ranges of activity that it has the same effect that would prevent a worker from accepting new employment or starting a new business, even if it's framed as an NDA or a non-solicit, would be prohibited. So another example, a non-solicit that says a departing employee can't go work for a vendor or customer of the company. It's called a non-solicit, but it has the effect of preventing that employee from accepting new employment. So that would also be prohibited and void under the law.
So what about, and this is probably an unanswerable question, but I mean, sometimes we come across industries or businesses where there's a defined group of potential customers that all of the competitors seek. If you have a non-solicit that says you can't solicit business from any of the customers that you've solicited business from on our behalf for a year, that it may effectively preclude someone from working in the industry for a year.
Yeah, I would agree. I would totally agree that if an employee was to, look at that and say, oh, well, I can't perform services because of this restriction, I think it's covered.
Yeah, so the FTC final rule does seem really pretty broad in terms of trying to capture other kinds of restrictive covenants. Even saying that they don't, it really does in many ways.
Exactly. I think the FTC was hesitant to carve out, non-solicits, NDAs, for this very reason, that if they're, if you call it that, if an employer calls it that, but it really functions to prevent and limit employee mobility, it's having the same effect. And so the FTC wanted the rule to read as broadly as possible to also capture other restrictive covenants that have the same impact.
But without a bright line test on NDAs or non-solicits, it just means there's going to be uncertainty, and therefore uncertainty leads to more business for attorneys, right? I mean, there's going to be
That's
litigation over
true.
whether an NDA or non-solicit. There will still be litigation. It will just travel to a different issue rather than non-competes. There'll be non-solicits and NDAs and confidential information and trade secrets and things like that.
Yeah. I noticed I jumped over this one mistakenly. Sorry about that. But the question about how the rules enforce, and that is, so, the final rule says you can't, have these agreements. They're not enforceable. You have to send out notices, all the stuff that Natalie talked about. So what is the penalty, or is there a penalty, and how does that play out? How does that get enforced?
Well, I mean, it's a good question, and we'll see. But a violation of the rule would constitute an unfair method of competition within the meaning of Section 5 of the FTC Act. Now, Section 5 of the FTC Act does not grant expressly a private right of action for someone to sue on it, and doesn't grant the FTC expressly rights to recover penalties from employers who might violate. So it's likely going to be the scenario that the FTC may, seek an adjudication in a court, cease and desist order to have employers stop using any non-competes. And if there are violations to that injunction, obviously there are going to be some significant penalties. But we also could see employees, independent contractors, any sort of private actors suing under kind of an unfair trade practices type claim, which in some states could bring attorney's fees, multiple damages. Now here in Massachusetts, it's generally held that unfair and deceptive trade practices claims don't cover employer-employee relationships. So it may be more difficult to bring that type of claim here under what's called Chapter 93A. But I'm guessing that's what, we're going to see a lot of unfair competition claims. When an employer goes to enforce a non-compete, we could have employees counterclaiming for that, for that type of unfair method of unfair competition claim. And so, we will certainly see non-competes invalidated, unenforceable, but the claims for damages against employers may be a little bit harder to obtain. But we'll see.
Even if an employer says, well, I'm not issuing any notices, right? Like, under that provision. So there's nothing that says that you get penalized for not doing that.
Well, the FTC can go in and issue a cease and desist order to you. Perhaps if you violate that, then you'll get penalized. But
got it.
No, and by no means am I advising that you just flaunt the rules. But because those violations could lead to penalties that we're not considering right now, even if they're not expressly within the FTC Act. They could be some other penalty. Someone could drive a claim of, perhaps who knows what the violation would be. Discriminatory violation, who knows? But based on a violation of this act.
Well, in terms of, not advising people to flout the rule, let's talk about whether or not we should send out notices, right? Because, and just I just want to make sure I'm clear, Natalie, that the rule says the employer is supposed to send out these notices to all employees who have agreements prior to or upon the implementation of the rule. Is that it?
Yeah, that's my understanding, that prior to the effective date of the rule. So a little bit of time, given the timeline that Chris outlined and the pending legal challenges. But I think our general advice on this point is just to wait and see. I don't think that employers need to rush to send out these notices quite yet, but it's probably advisable to have them ready to go in case the rule does look like it's going to take effect. So to that end, reviewing your agreements, reviewing your non-competes, and not only your non-competes, in light of the discussion we just had with regard to other restrictive covenants, taking a look at your non-solicits and your NDAs, because if those are too broad, those would need to be, notices would need to be sent for those agreements as well. So we would advise.
Just so I'm clear, so an employer is supposed to send out the notice to anyone who has in place a restrictive covenant that would violate the final rule. Is that right?
Correct. Yes. Notifying that employee that the restrictive covenant is not going to be enforced.
Which means you
So-
don't send it to the senior executives with existing
Who have a
non-competes, right?
pre-existing one, right?
And so, one of the first steps is every employer should think about who they consider to be those senior executives now, right?
Yeah.
Exactly.
Yeah.
Yeah, exactly. Because that would, that will feed into who needs to get these notices. And just, as we said, sort of being ready to see what happens, whether the rule looks like it's actually going to go into effect, just to ensure that employers can be prepared to comply if need be.
So that kind of gives us sort of a logical plan of action, I think, and that is, as you just said, Chris, the first thing perhaps we do is identify who in our workforce is a senior executive under these standards. Then do they have an agreement in place? And if not, do we want to make sure they have one in place? And then once you've gone through that, identify that, you say, okay, well, who do we have in the workplace that has an agreement that's not a senior executive, that has an agreement that would be invalid under these rules? Because those are the people we're going to have to be ready to send notices to and have that prepared. Right? That's as a means of getting ready for compliance come, whether it's September 7th or some other date or never, I don't know, but right, that's really the process you need to go through now to be prepared.
And I'd say even before step one is for many employers, figure out who actually has a non-compete
Right.
In your organization, because they could be in, I'll segue you into your last question, but it could be in documents other than ones that just say non-competition agreement, right?
Yeah, right. That's right. Well, and yeah, we want to make sure we did talk about this because this comes up all the time. Stock option plans and LLC operating agreements, other equity plans where, employee is offered some measure of equity to become an owner or receive stock options as part of their employment package. And typically or often those agreements will include a non-compete, for as long as you hold your shares and until you sell them, or for 1 year thereafter, sometimes you'll be subject to a non-compete. We had an internal discussion here as well. Is that, do those apply here? Do they not apply here? I think reading the FTC rule, I think the FTC will say, oh yeah, we're going to capture all those. Though it doesn't specifically say that. The rule doesn't seem to specifically say it, but it talks around it a lot. It talks about benefit plans. It talks about, springing forfeitures, other kinds of plans that, employees would lose some future benefit or some future right if they compete as being brought within the scope of the rule. So I think the answer is it's not entirely clear, but I think my gut is that the FTC will look to capture those within the scope of its rules once they get into enforcement and litigation. I don't know if you guys have anything to add beyond that.
Agreed.
Yeah, I think interestingly, the FTC, the text of the rule makes clear that they sort of decline to carve anything out beyond the sale of a business exception. So this other sort of gray area with different types of agreements, or, the way these restrictions can be baked into other sort of business structures, the FTC wouldn't really go beyond saying that non-competes pursuant to a sale of a business are carved out.
Right. Well, I think that's, and I think that's sort of the tone of the rule. That is, we're saying these specific things, but we're not ruling out anything that's not explicitly said, right? So it leaves a lot of discretion or open to the FTC going forward, and it leaves a lot of uncertainty for us. In any event, I think that brings us to the conclusion. Unless Chris or Natalie, you have anything else you want to add? I want to thank everyone for coming. Really enjoyed it and hope to see you again at our next session. Let us know if you have any questions. Take care, everyone.